I'm just waiting for the second attorney's connection to join us into the courtroom.
Okay.
All right. Judge Henderson, may I open court?
Yes, please.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 18-3079, United States of America versus Anthony J. Fareri, appellant. Ms. Taormina for the appellant, Mr. Smith for the appellate.
Ms. Taormina, good morning. You may proceed.
Good morning. May it please the court. Rosanna Taormina from the Federal Public Defender's Office for appellant Mr. Anthony Fareri. I'd like to reserve 2 minutes for rebuttal. The United States, as payee, currently has 4 separate but overlapping money judgments seeking to disgorge Mr. Fareri and his 2 co-conspirators of the ill-gotten gains they obtained through their involvement in the scheme to defraud, to which they each separately pleaded guilty. The subject of this appeal is the $3.6 million forfeiture order obtained in the context of Mr. Fareri's criminal case here in the District of Columbia. But before the government obtained that order, it also separately obtained civil disgorgement orders in the Southern District of Florida for broader conduct encompassing the criminal conduct charged in DC in pre-judgment or pre-interest amounts of $1.8 million for Mr. Fareri, a partially overlapping $3.4 million for Paul Fareri, and $82,500 for Douglas Zemsky. The government thus has outstanding money judgments totaling $8.9 million with no offsetting or contribution provisions, where there is no allegation that Mr. Fareri and his co-conspirators benefited from their scheme either individually or combined anywhere near that amount.
Although Ms. Taormina, in the briefing in this case, the government has said that it does agree to or would agree to some offset and has consented, as I understand it, to the district court entering an order to that effect. So it would be helpful if you would focus on, were that to happen, what would be left?
Sure. Yes, Your Honor. While we obviously agree that there should be an offsetting provision for Mr. Fareri's payments in the Southern District of Florida, the government did not address and has not conceded what we believe would need to also happen would be offsetting payments, offsetting Mr. Fareri and Mr. Zemsky's payments in the Southern District of Florida towards their disgorgement order, offsetting Mr. Fareri's forfeiture order, as the $3.6 million amount purportedly represents collective gains of the 3 co-conspirators. So there would also need to be the contribution offsetting provision as well. What then remains?
If
sure.
That were part of what the government were willing to agree to, on, as you say, on the notion that the joint and several liability against Fareri in his criminal case counts gains of, is it Fareri and Zemsky? So if the government were to agree with contribution being counted against Mr. Fareri's forfeiture liability, would there be any prejudice remaining to Mr. Fareri?
There would be, unless there was one additional agreement. The prejudice that would be remaining is that he has a $3.6 million forfeiture order on top of the $3.6 million restitution order. Now, we absolutely concede that the government can collect the restitution goes to the victims, forfeiture goes to the government. Now, there is a provision in Section 981 that authorizes the Attorney General to transfer forfeited property or monies to the victims, such that any forfeited money would essentially offset restitution. In that, if that happened in this case, if that was definitely going to happen, then there would really not be any prejudice to Mr. Fareri, because then that $3.6 million would only, even though it would sound in forfeiture and restitution, he would only be paying it once. And no matter what, he has to pay the $3.6 million
I thought they'd already
restitution.
agreed. I'm sorry to interrupt.
No, please.
I thought that was what the government did already clearly agree to, was that any amount paid by Mr. Fareri, which I understand under federal law would first be credited toward the restitution amount, would offset his forfeiture liability.
First of all, I know that the two things, that agreement is not self-executing.
No, but I'm assuming that they
Okay.
would be willing to jointly move the district court to have an order entered to that effect.
Yes, yes, I know that agreement accounts for prospective payments. I will certainly, while Mr. Smith is arguing, I will certainly confirm that agreement also accounts for payments in the future, as opposed to, sorry, the agreement accounts for past payments, because Mr. Fareri, before entering into this agreement, made several payments to individual victims that were never credited to him. So I know that agreement accounts for those payments. I have to make sure that it also accounts for the prospective. Because that agreement wasn't, the court didn't enter that agreement. It's not currently, I think, like I said, I don't believe it's self-executing. I've talked to the clerk's office and they need the court to sign off on it, and he declined to do so.
We can obviously ask Mr. Smith about this, but I mean, it's really three
Yes.
buckets, as I understand. It's before the agreement, after the agreement, but before now, or before any district court order, and then from any district court order going forward into the future. And we'll hear from Mr. Smith whether that's something the government would agree to, and if not, why not, on which part?
Yeah, and certainly to be clear, that is not to concede that the forfeiture order is of $3.6 million is correct. It's only, I think, agreeing to the fact that there would be no tangible prejudice if it remained in effect. So I still believe that the forfeiture order is incorrect at $3.6 million. It should be, we would need further development on exactly what it should be, but it should sound in the $1.2 million range, referencing the Southern District of Florida pleadings. But I do concede that there would be no tangible prejudice if the government doesn't plan to collect twice the forfeiture on top of the restitution. But I do want to point out that we understand that the government can collect restitution and forfeiture separately, and that's what we are worried about in this case, because, like I said, if it collects, right now it has several outstanding orders from numerous people, none of which reference each other, and Mr. Fareri, at the very least, is on the hook for much more than he obtained through the scheme to defraud. But absolutely, Your Honor, if those agreements were in place, there would be no tangible prejudice to Mr. Fareri. The government does also concede at this point, not in this point in the proceedings, but at this point in the state of the law, that the Supreme Court's holding in Honeycutt does apply to the forfeiture statutes in this case, which would prohibit, at least prospectively, the forfeiture of money and or property under a theory of joint and several liability. So they do agree that if this case were in a different posture, if we were on plain error review, that forfeiture amount would be wrong. We are in a different posture. We are in ineffective assistance. But I believe that the fact that the error is plain also informs the deficiency of the
Now, if the case were
of
brought
counsel's
today, the error
deficiency.
would be plain, but at the time, it was pre-Cano-Flores and pre-Honeycutt, and so my understanding is that under our case law, it wouldn't have been plain error, but is it nonetheless ineffective assistance, and how so?
Well, that's
Statute doesn't
what we
use the
argue.
word obtain, and
Yes, that I would say I wouldn't necessarily concede that it wouldn't be plain error. There's case law in the circuit that acknowledges, and I believe that I know we cite one case in our brief. I believe it may be Soto, but there's also, I know, in United States versus Lorries, there's a concurrence that details this, that even in the absence of binding precedent, and even in where there's conflicting out of circuit precedent, if we're talking about plain textual language, that an error can still be plain, that this court can recognize the error as plain. But even so,
you focus on the language, but the word obtained doesn't appear in the statute here. And the word that was really the focus of the kind of Flores analysis, and so it has to be more conceptual, doesn't it? Your argument has to be, well, what forfeiture is the, having in hand or getting or taking or obtaining property, and that therefore it should be measured differently from the victim's loss, which is, I think your brief does a pretty good job of spelling that out. But then the question is, based on what legal sources was that an error that was sufficiently evident that it should have been raised by competent counsel?
Sure. Well, two answers to that. Well, one, the government does concede that Honeycutt now does answer this question. So I'd be curious why the government takes that position itself. But my answers to the outside of that are the fact that there are forfeiture, the forfeiture allegation in this case, the plea language, and then the consent order of forfeiture itself uses the words obtained directly and indirectly. It uses the words that are in that are the operative language in Honeycutt. So the actual, even if counsel didn't look up the statutes, the actual documents in this case that are binding, the plea document, most operatively uses that language. Second, 981 is a civil forfeiture statute. It needs to be incorporated into the criminal proceedings through the other statutes that the government cites in the forfeiture allegation and in the plea document and in the consent order forfeiture. And those statutes do use the word obtained. So I think that may be one of the reasons that the government is conceding that Honeycutt does govern, but the government itself, who wrote the plea agreement, used the word obtained in its plea agreement. So even on the face of the language that Mr. Fareri agreed to, it says that he's agreeing that this amount represents the money that he obtained through the result of the scheme, and that's just not the case. And I don't believe that the government believes that he obtained that amount of money either.
Let me ask you, counsel, about this attempt, I guess, by Judge Sullivan to transfer jurisdiction to the Eastern District of New York. He hasn't done it on the DDC docket yet, so we have jurisdiction. But, tell us what you know about this, because why should we tie the hands of the Eastern District of New York?
My understanding is that is a transfer of jurisdiction only for purposes of supervision. So it's not a transfer of the entire of the case. It's a transfer of supervision so that the Eastern District of New York can supervise Mr. Fareri, because that's where he lives. And that commonly happens in cases where our clients do not live within the jurisdiction. They're supervised outside of the jurisdiction. And so you transfer jurisdiction for supervisory
all right.
purposes.
That
But
hasn't
the
been
case
effected
remains
yet.
here. I apologize.
That has not
No.
been effected yet.
Not, I actually do. My understanding is that Mr. Fareri's probation officer is in New York. It's not, he's not being supervised by DC. But again, the case itself hasn't been transferred. So if my understanding is in light of that, if Mr. Fareri were to violate his supervised release, he would be violated here in DC before Judge Sullivan, even and not in New York.
All right. So
That is just my understanding.
So this is a limited transfer of jurisdiction for supervision, which hasn't been effected. And when it is effected, it has no relevance to the issue we're dealing with, the forfeiture and restitution.
Yeah,
Okay.
it would have that is my understanding,
Okay.
that it would have no
All
bearing on this court's jurisdiction on
All
this
right.
issue.
Judge Rao, do you have any more questions? Or do you have any questions? All right.
I do not. Thank you.
All right, Mr. Smith.
Thank you.
Mr. Smith?
Thank you very much, Your Honor. May it please the court, Peter Smith on behalf of the United States. The district court did not err in rejecting appellant's ineffective assistance of counsel claim, and I'll address initially the deficient performance prong of the Strickland analysis. The defense counsel made a reasonable strategic decision to advise appellant to accept the very favorable plea offer from the government and not to further contest what the parties below described as the loss amount, which was all of these things put together in the government's plea offer to appellant, which included the forfeiture, it included the restitution amount, and it included, the terms of the offenses to which appellant pled guilty and other benefits he received in terms of his guideline range. For example, the prospect of a 5K departure from the otherwise applicable guideline range. Both during the evidentiary hearing in this case, both defense counsel and appellant himself testified that the government insisted on what they called the loss amount, which was both the same amount for the amount of forfeiture and for the amount of restitution, and that did not give defense counsel room to further negotiate that amount. The government's plea offer was tendered with a 2-day turnaround, and defense counsel and appellant had to make that decision quickly. So it was certainly a reasonable strategic decision on counsel's behalf. And then I wanted to make a couple of points about.
Before you
Mr.
move
Smith,
on,
could I?
go ahead.
Oh,
Judge Rao, go ahead.
oh, thank you. Mr. Smith, I had a question about the basis for the government seeking forfeiture here. So the government cites 28 USC 2461C, which sets out the requirements for forfeiture. And then it cites 18 USC 981, which provides for forfeiture for certain offenses.
Mm-hmm.
Offenses doesn't include mail fraud, the offense that Fareri pleaded guilty to. So I'm wondering what the statutory, is there another cross-reference for why the government can seek forfeiture for mail fraud here?
I guess I have two responses, Your Honor. First of all, I don't think appellant has raised that argument that the government lacks authority for the forfeiture award. And my understanding from briefing this case was that there was a basis that the fraud, the count of conviction, the mail fraud, was a basis for forfeiture. So,
but under what statute? I mean, I think forfeiture is a pretty serious penalty. So it seems the government should know what statute it is imposing forfeiture under, whether or not the appellant raises that. I mean,
I understand, and all I'm saying is I don't know offhand. I remember when preparing the government's brief that I looked at the statutory authority and I believed that there was authority for that. But since appellant hasn't briefed that or raised that argument on appeal, and I didn't look at that in preparation for today's argument. But I believe that there is authority for that.
Okay, that does seem worrisome to me, that the government can't state the statutory authority for its forfeiture penalty. It seems like that should be a pretty straightforward question.
Well, it would be, Your Honor, if appellant were raising a challenge to the forfeiture award or the judgment, but he's not. He's raising an ineffective assistance of counsel claim.
Oh, I understand that.
Okay, and under that claim, we would be looking at whether counsel's actions were reasonable, both on the deficiency prong and then whether appellant has shown a reasonable probability of a different result on the prejudice prong. So,
so Mr. Smith, on the you talk about the benefits that Mr. Fareri obtained, and it does seem like if this were in fact a strategic decision that it might be reasonable, but the record really shows, as you mentioned, and I appreciate the accuracy and fastidiousness of your characterization, that you talked about what the court and the parties characterize as the loss amount. And it's very clear reading the record that they were really equating loss amount and the amount gained, unlawfully gained through this conduct. And so it's hard to say that there was even consciousness of this, what we now know in light of kind of Flores and Honeycutt, to be an error, that there was even consciousness and therefore a strategic decision being made at the time that one could characterize as reasonable or not. I mean, if it's a kind of error that nobody's really paying attention to, and counsel for Mr. Fareri had said to the government, look, the total amount in terms of restitution should be the 3.6 or 8, but 6, but the forfeiture amount, because it's measuring something different, should be lower. It's not clear that the whole deal would have fallen apart and that the benefits that Mr. Fareri stood to gain from pleading would have gone away. So how do you respond to that concern about effectiveness or not?
well, I think I have 3 responses, Your Honor. Starting with the last part of Your Honor's point, I think it is speculative to think that the government that had defense counsel taken on the forfeiture fight, that the government would have simply acceded to that and not otherwise changed the terms of the plea agreement. I think that's purely speculation. And under the Strickland standard, where appellant bears the burden of showing a reasonable probability of a different result, he hasn't proven that. And then I have 2 other responses. One is that the government treated all of these amounts as part of its plea agreement. So I guess part of my response is that defense counsel had to play on the government's playing field, given the terms of the plea offer. The other part of my response is that there was a reason that all of the parties below used these the term loss amount as sort of heuristic to mean all of these different amounts. And that's because on the facts of this case, the loss amount and appellant's proceeds were the same. Appellant's scheme was one where he sold worthless stock to his clients. So it seems to me that the victim's losses in this case were the same as appellant's proceeds. And therefore there was
no... Really, because the proceeds, he guides his clients to buy stock that aren't worth what they're supposed to be worth. The sellers of the stock, who are the co-defendants, actually received that money from Mr. Fareri's clients. Mr. Fareri never himself in any kind of ownership terms received any of that money, right? He gets kickbacks then from the co-defendants, but the amount that he ever had in his possession and control wasn't the entire loss amount, was it?
Yeah, I would agree with that. And I would say that he got $820,000 from Fareri. I think what the court is referring to or suggesting is the joint and several liability issue. The forfeiture amount is clearly predicated on joint and several liability, which, right, as has been discussed a little bit earlier this morning, was proper at the time of the plea agreement. And appellants has made this argument on appeal many years later that counsel should have somehow anticipated the result in Cano Flores, but it simply isn't, it wasn't at that time that obvious that appellant's counsel should have anticipated that. It was a much more murky legal issue. And also this was in the context where appellant received a very favorable plea offer. Appellant and appellant's counsel were both focused on reducing appellant's term of incarceration. Each of the dismissed counts, for example, the mail fraud and wire fraud counts, I believe, were a 20-year maximum term of incarceration. And appellant also had the prospect of the 5K departure from the guidelines range. He also got an adjustment for accepting responsibility. So he did get an extremely favorable plea offer. And when you're evaluating ineffective assistance, you've got to consider that context.
Of course, of course. I wonder if you could address the points that we asked Ms. Taormina about in terms of the government's, I think, quite reasonable proposal to offset, and just, you know, the ineffective assistance issue, we could theoretically dispose of it on the basis of lack of prejudice, but that would require us to determine that there was in fact a lack of prejudice. And I'm not sure that what the government's offering is sort of all eliminates what I think of perhaps as at least three separate sources of prejudice. So could you address what the government is willing to move the district court to do in terms of counting the various relevant payments here?
Yes, I understood that government's offer, which is set, I don't know it offhand, but the exact, the prosecutor's statement is recited in the government's brief, exactly what he agreed to and the citation for it. And my understanding of that is that any amounts appellant pays either in disgorgement or in forfeiture or in restitution would be offset against the other. And what the prosecutor was saying during the remand hearing was that the government's already done that for the payments appellant had made previously. And that I understood the prosecutor to be saying that any subsequent payments would also be offset. And that was the discussion that we had, we meaning the U.S. Attorney's Office, internally in preparing our brief, where we said, you know, that we understood that to be the case, and that we would, you know, agree to the entry of an amended order, making that clear, that offset clear.
I don't know if you have authority to respond, but one of the points that Ms. Taormina raised was, you know, given the claim of ineffectiveness with respect to the joint and several liability for restitution, the briefing, the government's briefing, doesn't undertake to credit any payments, however unlikely, that Mr. Fareri or Zemsky might make to satisfy their obligations, restitution obligations. In other words, part of the amounts on which the joint and several liability, forfeiture liability against Fareri are based. And I don't know if the government, I mean, that would be a prejudice claim that, and I wonder if the government's in a position to say that were they to be able to make payments against their obligations, would those also be credited against Mr. Fareri's joint and several forfeiture liability?
Well, the short answer, Your Honor, is that, you know, we didn't discuss that beforehand, so I wouldn't know the government's position on that. The reason we didn't is because I had never heard that any mention of that sort of offset until today. I know that appellant challenged during the idea of joint and several liability and argued that defense counsel should have anticipated that, but I've never heard the argument about offsetting payments that Fareri or Zemsky made until today. But I would add a couple things to my response. And one is that the forfeiture judgment itself and the restitution order, both of those orders, which are part of the court's judgment, are not before this court in the sense that appellant can directly challenge those orders. And he hasn't on appeal. He's raised an ineffective assistance claim. And I would wonder whether appellant's new argument about prejudice is really a prejudice argument or whether it's really a challenge to the judgment or those orders over which this court lacks jurisdiction. Not only because appellant never raised it, but because appellant can't challenge those orders directly. He can only raise an ineffective assistance challenge.
Right. And I think they're before us in the sense that were we to find ineffectiveness with respect to either of the two related theories, which I understand to be one, that it's double counting against Mr. Fareri to make him liable both for disgorgement and criminal forfeiture. And two, just looking at the criminal forfeiture, that it was ineffective not to limit his forfeiture to his own gains, and therefore the joint and several issue, the failure to sort of push back or at least raise or identify or even be aware of that, would also have been ineffective. And to the extent that he's making an ineffective assistance of counsel claim with respect to one or both of those, if it were a meritorious claim, then the order would be before us, no?
Yeah.
I'm assuming that so in talking about the prejudice prong, obviously he doesn't get there unless he has crossed the threshold of ineffectiveness. But were the government voluntarily willing to make an undertaking that would eliminate the prejudice, that we wouldn't need to reach that threshold issue. So I'm just trying to explore what really is before us in light of the undertakings.
I understand. I mean, if the government did it, if the government did that, I suppose, that would solve part of the court's issue. But
or could resolve the whole case. That's what I'm exploring. I'm trying to figure out what actually we have to decide.
Yeah. No. Okay. I see what you're saying. In terms of the prejudice, I mean, if the government did that, it would obviously sort of moot this question.
Right. And I just wonder what interest the government has in resisting that, because it seems like I'm just asking you, what is the government's interest in resisting that?
Well, on the first part of the court's question about the offset of the disgorgement and the forfeiture, we've already agreed. We've already agreed that we would do that. So that's off the table. The second part, I guess, the question is whether, in order to reach that, the court's got to find deficiency. I mean, Strickland says you go through this analysis, and if you fail on either prong, if you're the defendant, you can't prevail. And so it's appellant's burden to show both deficiency and prejudice. And
of course.
You wouldn't necessarily get to that question even if you disagreed with me on the prejudice point, because there's no deficiency. I mean, I know you're asking me about the prejudice point, but
right, because we may disagree. I mean, about deficiency, depending on how clear one thinks the concept of forfeiture being about gain and restitution being about loss is. That seems like one could say way before kind of Flores and Honeycutt, pretty clear distinction conceptually between those two things.
But I wouldn't say obvious enough that appellant's counsel had a constitutional duty.
No, I understand. I understand your position on that, but I'm just saying that it's in the case, and the government has come forward and said, look, we get it, and we're willing to do some cross-crediting. And so all I'm asking is, if the government is also willing to credit payments by the co-defendants toward their restitution amounts as against Mr. Fareri's forfeiture amount, that could actually, eliminate the claim of prejudice altogether. And so it would be helpful for us.
No, I understand, and I simply can't answer that.
Yeah. So it would be helpful to know that, and perhaps you could ask. I mean, if the government has no objection to that, that would obviate need to decide an unnecessary.
I understand, and I'll take that back to the office, and we'll, I suppose if the court is asking, which I understand you to be asking, we'll file a letter one way or the other with either stating our position,
That would be great. And the other thing that's a little bit unclear to me from the record is with respect to either or both the offset, within Mr. Fareri's own kind of two columns, or the crediting from the other co-defendants, pre-agreement, post-agreement, but pre any amended consent, motion, amended order, and going forward. Is there any distinction in the government's view, or would it be, assuming that all, whenever it occurred, that the crediting offsetting would take place? It'd just be helpful, I think, to know that.
Right. I'm pretty comfortable now saying that, we did discuss that, and my understanding is that it is, it covers
all at any
past
time.
and prospective relief in terms of the offset. I believe that to be the case. So I think I can answer that now, but if we're going to file a letter, we may as well file, explain our position on both.
Great. Thank you.
All right, Judge Rao, do you have any questions of Mr. Smith? All right, Mr. Smith, before opposing counsel replies, I'm concerned, like Judge Rao, with whether or not there's a statutory basis for the forfeiture. So once counsel concludes, well, I'll just say it now. I'd like you, along with the inquiry you're going to make about the amounts and so forth and the offsets, to also address the statutory basis for the forfeiture. And you may need longer to get permission about the offsets, but I'd like to know, frankly, by say noon tomorrow, what the statutory basis is. That I think you can submit immediately. And well, since we're all here, if that does take care of the case, it takes care of the case. If it doesn't, we'll get an order out today about how much time we'll give you to consult with whoever you need to consult with about the offsetting amounts.
Okay, I understand, Your Honor. Thank you.
All right. All right, Ms. Tamarina, why don't you take 2 minutes?
Thank you, Your Honor. Because it would be embarrassing for me to not have raised the issue. I do believe that potentially the government's forfeiture authorization is not in the actual subsection that they cited. It looks to be in 981A1D little v. That one.
All right, say that again. A1 what?
Oh, A1 big D little v, which authorizes forfeiture for relating to mail fraud. So that specifically cites 1341. VI is 1343 for wire fraud, and which is important to note as well. D does contain the obtained directly or indirectly language. So the government's argument with respect to the absence of that language in 981C is not operative.
Thank
so
you, Ms. Fareri, for that.
I could be wrong. I mean, I could be wrong, but I believe that that's where it is, and that's potentially why we didn't raise failure. That failure. Sure. And then with respect to, I wanted to say I pulled up the parties' joint proposal. That proposal only deals with past payments. It does not deal with how prospective payments will be credited, whether they would be credited to both forfeiture and restitution. So there's still that outstanding agreement that we would ask for. I also two very quick things.
Just clarify, the timing. So when you say past, do you mean pre-plea or between the plea and now?
Actually, there were pre-judgment, I suppose. I'll have to check the date of all of the payments, but there were there were pre-indictment payments, there were pre-plea payments, and there were pre-judgment payments that Mr. Fareri, one of the things that they spoke about at length at the sentencing was that Mr. Fareri began to repay some of the victims before even the criminal case was brought. And so there was a question about how these payments would be credited. And so this agreement allows those payments, the plea agreement referenced to those payments and allowed for offsetting, but it was not specific enough. So this agreement addresses those payments. It does not address prospective payments towards restitution that would be credited towards forfeiture. And again, that is permitted. It's permitted. It's discretionary, but we'd ask that the government exercise its discretion.
And when you talk about prospective, I'm just worried about. So there's before the judgment, you talked about 3 categories that precede the judgment: pre-indictment, plea, and then pre-judgment. And then you talk about prospective, but then there's between the judgment and prospectivity. I don't know if anything happened, but there is a period of time that has passed, quite a long period of time. And
that passed.
So I also would want to, just whoever's describing this needs to describe it in a way that covers unambiguously whatever periods the government is willing to do this for, which I assume would be all relevant periods, but you don't know whether
I think that's
payments between judgment and now.
No, there have been payments between judgment and now. The government does, they're de minimis, but and they're being collected through the probation, I believe, and through the clerk's office. I am unaware of that accounting, but we could, I believe that if there was going to be an agreement, we could find a way to word it such that any payments, both, prior and in the future, we could certainly find a way to word that.
Provided the government were willing to do that.
Yes, absolutely. And with respect to the offsetting of the co-defendant, or sorry, not co-defendants, but co-conspirator payments in the Southern District of Florida, the government described that as a new argument, and I don't believe that that's a new argument at all. It's a way to it's a remedy to remove prejudice. So I believe that the argument is definitely laid out before the court. Finally, I want to say one more thing. As the government just numerous times has described the plea agreement in this case as very favorable, and I have to push back on that. The only benefits I can see from this plea agreement versus him just pleading straight to the indictment, which he could have done, and that is something that the courts have recognized when you're looking at the prejudice between in the plea context that you compare the prejudice or the outcome to pleading straight to the indictment is the one additional government moving for one additional point for acceptance of responsibility, which courts have the discretion to grant in any event, and also just when there's 3 counts, the court assesses $300 versus when there's one count they assess $100 in essentially court fees, and so he didn't have to pay the difference in the counts. But Mr. Fareri, those dismissed counts were still considered relevant conduct. So Mr. Fareri was held accountable in his guidelines calculation for all of the conduct that was referenced in the indictment. None of that went away. He was precluded from arguing this question. He was precluded essentially from arguing against his loss calculation, against his restitution calculation. I would disagree that this was a particularly favorable plea agreement. So that's
got your position, Judge.
Yes,
Rao.
thank you.
I just had one thing. I was just looking at the provision that Ms. Tarmina that you cited for including the mail fraud, and I'm not sure that provision is applicable because it refers to Section 1341 relating to mail fraud, but then specifies if such violation relates to the sale of assets acquired or held by the FDIC as conservator or receiver for a financial institution, which is not the case here,
Okay.
where Mr. Fareri, had, his
No.
various stocks and companies. So unfortunately, I don't think that
I
relieves
understand.
Smith of his obligation to provide us a statutory source for this civil forfeiture. But
My
thank you.
understanding is that it might be under 981A1C, which cross-references specified unlawful activity in 1956C7, which cross-references 1961-1, which does include 1341. But you'll get back to us on that. The government will get back to us on that.
Well, I think both of you ought to, by noon
Great,
tomorrow,
yeah.
submit what you think is the statutory basis for the forfeiture. And then we'll get an order out later about Mr. Smith about how much time to consult with your colleagues at DOJ. All right. Thank you all. And let's go to the next case, Madam Clerk.
Thank you.
Case number 20-1148, National Treasury Employees Union petitioner versus Federal Labor Relations Authority. Mr. Shah for the petitioner, Mr. Peters for the respondent.
Mr. Shah, proceed, please.
Good morning, and may it please the court. I'm Par Shah for the petitioner, National Treasury Employees Union. In the 2-to-1 decision below, the majority of the Federal Labor Relations Authority held that an NTU bargaining proposal related to telework violated 2 management rights provisions in the federal sector labor statute. It marked the first time, as far as we know, that the authority has ever found a telework proposal to be non-negotiable. There are 3 major areas that I'd like to focus on today. First, the authority's misinterpretation of NTU's proposal. Second, the authority's failure to address contrary precedent. And third, the authority's failure to adhere to its own regulations or to explain its departure from them. First, the central issue in this case is whether the majority properly interpreted NTU's proposal, which it viewed as creating a presumptive entitlement to 80% telework. If that interpretation is wrong, the statutory rulings at issue here, which flowed from that interpretation, can't be sustained. And here the authority's interpretation is plainly in conflict with the proposal's text, related sections of the party's existing telework article, and the bargaining party's shared understanding of the proposal. In contrast to the majority, neither of the bargaining parties interpreted the proposal's text as creating a presumptive entitlement to 80% telework. They view the proposal as allowing eligible employees to seek an additional 1 to 2 days of telework, with management retaining its discretion under the party's existing telework article to deny any such request. The parties, and this is reflected in the record of the post-petition conference, the parties understood the proposal would operate in conjunction with related sections of the party's existing telework article. And those sections make management's discretion here unmistakable. Among other things, those related sections speak to the agency's explicit discretion to deny a telework request or to rescind a telework arrangement if there is interference with the agency's ability to accomplish its work. The majority's interpretation of NTU's proposal hinges on this conclusion that provision D of the proposal, which states that employee requests for extended telework will not be unreasonably denied, creates a presumptive entitlement to 80% telework. But nothing in the provision's language supports that conclusion. On its face, that language explicitly sanctions denials of telework requests so long as those denials are reasonable. And critically, neither of the bargaining parties viewed this language as limiting agency management's discretion to deny telework requests consistent with the party's contract. On appeal, the authority makes 2 points to defend the majority's interpretation of NTU's proposal. First, it says that the majority actually interpreted the proposal in the same way as NTU does, but that's simply not true. We do not agree that the proposal creates a presumptive entitlement to 80% telework. Second, the authority now says that the majority's interpretation was based on the potential application of NTU's proposal, which in the majority's view might lead to grievances and arbitrations. But that also isn't true. In footnote 11 of the majority's decision, which is on JA 228, the majority explicitly bases its interpretation of NT's proposal on the proposal's plain wording, namely provision D, the unreasonably denied language. While it then, after setting forth that interpretation, speculated that in practice, this language might lead to grievances, that speculation was not the basis for its interpretation. And more fundamentally, those policy concerns have no bearing on the legality of NTU's proposal. A related point, Your Honors, standing alone, the authority's failure to consider the related sections of the party's existing telework article renders each of its rulings arbitrary and capricious. That was plainly a failure to consider all of the relevant information. The bargaining parties explicitly agreed that NTU's proposal would operate in conjunction with those related sections. The authority has argued on appeal that the majority must have implicitly accounted for two of those four related sections because they were quoted. They were referenced in NTU's proposal, which the majority quoted. But nothing in the majority's analysis reflects that it took into account those related sections. And regardless, the authority on appeal has no explanation for the majority's failure to consider the two other related sections in the party's existing telework article, which explicitly speak to management's discretion to deny telework requests if there is any interference with the agency's ability to accomplish its work. As to the second category of legal error, the authority failed to deal with conflicting precedent that was directly on point. The authorities.
Mr. Shaw, if I could ask you about those arguments, do we have jurisdiction to consider those arguments? Because we cannot consider an argument unless it was raised before the FLRA under section 5 USC 7123C. And our court and the Supreme Court have said that that's a jurisdictional argument. So did the union raise that before the FLRA? I mean, I don't think that it sought reconsideration, did it, of the FLRA's decision? And if it did not, then why aren't we barred from deciding that issue?
Your Honor, I just want to confirm which issue Your Honor is speaking of. Is it the misinterpretation of the proposal issue or the? No,
I mean, well, that issue was before the FLRA, but the other arguments that you made that the FLRA sua sponte considered the right to direct employees, and also that it departed from its own precedents without sufficient explanation. Were those points raised? I mean, I assume they were. I mean, can the union point to a place where they were raised? Because I assume they would have been raised in a motion for reconsideration, but I don't believe there was one here.
So, Your Honor, taking the issues one by one, our argument that the authority failed to properly consider its 2011 decision in NAGE, which we believe is directly on point. NAGE was specifically argued below, and we provide the citation in our briefs. We argued that NAGE should have governed, and likewise, Member Dubester in his dissent below agreed that NAGE should have governed. In terms of the authority's failure to sufficiently explain its departure from a specific area of its right to assign work precedent, which is a separate argument in our brief. We again relied on those cases in our briefs below. Where the authority has raised a 7123C argument, it relates specifically to a reliance argument. And we stated in our reply brief that, yes, we did not raise that reliance argument below.
But even this argument about the failure to fully consider the precedent, it would seem that under our decision in Department of Commerce versus FLRA, that we wouldn't be able to consider this issue unless NTU raised them on a reconsideration motion before the FLRA. And that's a requirement. So it doesn't matter whether or not the FLRA raises it.
Your Honor, I'm not aware of any requirement that we seek reconsideration before filing a petition for review in this court.
Well, how would you distinguish the facts here from the Department of Commerce case?
Your Honor, I don't have that case in front of me, and I don't believe raised. the briefing in this case. In general, Your Honor, the statute 7123C gives us a right to seek review of a decision of the authority, which we have done here.
Only for issues, however, that you raised before the FLRA.
Yes, and in terms of a failure to adequately deal with precedent on point, Your Honor, that's just a basic procedural error in our view that is from the authority's decision. And I'm not aware of any separate requirement that we must seek reconsideration and raise that error before raising it in a petition for review in this court.
So in the Department of Commerce case, we held that the jurisdictional provision barred our consideration of the issue because the agency there raised for the first time that the FLRA misconstrued its precedent. And we said that we could not consider the petition for review because there was a failure of the government. In that case, it was the agency to reconsider on the ground that the FLRA had misconstrued its precedent. So isn't that, well, I mean, if you're not aware of that case, but I find it hard to see how your circumstance is distinguishable from the Department of Commerce case.
Your Honor, I would have to take a look at that case, and we would be glad to submit something supplemental on that case if Your Honor prefers. Separately, we believe that the clearest basis for reversal here is the error that we just discussed, the plain misinterpretation of NT's proposal. From both of the management rights rulings that issue here flow. The misinterpretation of the proposal and the failure to consider what are indisputably pertinent provisions of the existing telework article, the errors would stand regardless of the issue that Your Honor just raised. And we believe the court needs to go no farther with those two issues.
All right. Judge Pillar, do you have any questions?
I don't think so, thanks.
All right, we'll give you a couple minutes in reply, Mr. Shaw. Mr. Peters.
Thank you, Your Honor. So as far as to go to the argument that the union primarily relies on, which is that the authority misinterpreted the proposal, the authority squarely addressed this argument in footnote 11 of its decision, where it was addressing the dissenting member, and it said, the dissent reads the proposal as though it merely sets forth minimum requirements for telework while allowing supervisors unlimited discretion to deny telework requests from eligible employees. But that reading cannot be squared with the proposal's plain wording, which creates a presumptive entitlement to 80% telework for employees who have teleworked at least 6 days per pay period the previous year and have not had any performance or disciplinary issues. The proposal creates a strong presumption that all such requests will be granted by mandating that telework requests from eligible employees will not be unreasonably denied. In practice, this means that any manager who denies 80% telework to an eligible employee could expect a grievance.
So, Mr. Peters, so it's a two-step proposal. There's the more limited telework, and then there is the expanded telework. But as a threshold to either or both of those, there are the various provisions that are, basically expressly preserving management prerogative. And is it your view that once someone had completed a year of the more limited telework, that those somehow go away, or can't they could still be asserted presumably by management?
Well, so yeah, that's the fact that management might have little escape hatches within the proposal to deny telework for various stated reasons.
Well, those are pretty substantial escape hatches. We don't need to quibble about the characterization, but the agency never asserted that the prior proposal was non-negotiable, and presumably it's because they felt that it allowed them adequate management prerogatives, no?
Well, so what the reason why the agency objected to this proposal was because it did allow it added in the language that requests for 80% telework or extended telework will not be unreasonably denied. And so we can see how that would work in practice from two of the cases that the authority overruled. in HHS, the agency had made a determination that it was mission critical that grievant be in the office to work with others through brainstorming and daily interaction, developing a new strategy. An arbitrator said, no, I don't find that that's substantiated, and the authority agreed with it, with that in that case. And then the authority in this case overruled that. In USDA, Detroit District 2004, the agency determined that certain positions were not amenable to flexi-place agreements. Once again, arbitrator said, I don't agree. And the authority said, well, upheld the arbitrator. So the risk that the impact on management's right in this case was not theoretical. I mean, the union calls it get wild assertion or a extraordinary chain of speculation. Just those two cases that the authority cited, that was just the facts. The agency had made a determination as to the categorization, and
I follow that argument up to a point. The difficulty that I have is that the unreasonably denied only comes into play after the agency has checked the boxes. It's way back at the beginning, the threshold boxes. This is not something that for us is, and I don't have the language right in front of me, but this is not one of those, not so much one of those, what you call the escape hatches. And so the unreasonably denied is only applies after the agency has not deployed an escape hatch. Is that right?
I don't believe that that's necessarily right, because the language is unqualified. It just says that employee requests for expanded telework will not be unreasonably denied. I would think that would leave up to an arbitrator the grounds for the agency's decision to deny on expanded telework.
So you're reading that to apply. I mean, this is not an argument that I saw anywhere prior in this case or in your briefing here, but you're reading that the unreasonableness to modify that perhaps the agency does have to approve expanded telework for somebody who's had performance or disciplinary issues, if denying them would be on that ground would be unreasonable, or an employee whose work is not amenable to a telework arrangement, you're anticipating a grievance on the ground that that decision was made unreasonably?
Well, so the way this would work is there absolutely would be a grievance if expanded telework were denied, because it says if that was unreasonable. So perhaps there's an issue even with respect to something like discipline. You could say,
okay, so just to be clear, if the agency says, I'm going to deny this telework request under the prior policy and that the parties bargained for, which allows me, the agency, to deny telework if approving it would interfere with the agency's ability to accomplish its work. I need these people to be here in person. They can't work remotely. I need them to be here to get the job done. So those people don't even get any telework at all. And presumably the agency could determine that even for somebody who had had a year of telework under the limited telework, right? And just say, no, this is going to interfere with our ability as an agency to accomplish our work.
Well, so the fact is there wasn't the expanded telework category. And so first off, the fact that the parties previously agreed to something.
No, I understand that, yeah.
Not determinative, but yeah. The expanded telework category and the unreasonably denied language is new. So
I get that too.
For this proposal. So the union basically says, look, the agency can deny for a litany of reasons for any reason. But if that's true, and the note that the authority just said that its holding was simply that this affected management's rights. If that's true, that and I don't think it is, that the telework can be denied for any reason or no reason, and it doesn't place any constraints on that choice, that would still, under the authorities holding it, can still be bargainable as a procedure, right? So a procedure that management will observe. So, and that was not an argument that was raised by the union. So, but again, I think that another clue here is if you look at Joint Appendix 15, which is a not this specific proposal, but it is part of the proposed article. The tile work is not an entitlement is crossed out, and it's replaced by the use of telework is not an entitlement unless an employee meets the criteria for eligibility established under this article. So that's just a way of amplifying the fact that the unreasonably denied language, that the authority read this correctly. The authority and the agency also urged this repeatedly, that the combination of the expanded telework category plus the expanded telework will not be unreasonably denied means that there are substantive constraints on management's ability to deny telework, because it creates the prospect, the very real prospect, that the denial will be grieved. And it also just linguistically, if you look at it, the phrase employee request for expanded telework will not be unreasonably denied means that you can pretty much expect that if you're in that category and you're a manager that the employee is pretty much entitled to that, and the manager will have a real uphill climb in saying no, we're denying it.
I'm having a hard time following that, given what I'm referring to as these threshold prerogatives on the part of the agency, which remain in the policy. And so the unreasonableness is only assuming that none of those prerogatives prevented telework in the first place. And I don't see the extended telework as enhancing the nature of the employee's bid for telework. It just expands the scope, and it's still subject under the express terms of the proposal. It's still subject to all of those threshold prerogatives. So it's just, I mean, I understand it's a practical matter. People can grieve anything, and arbitrators can make mistakes, but that's not really the gravamen of your argument. I mean, the notion that people would bring baseless grievances and that there's some risk that any employer faces that an arbitrator could wrongly credit them, like that seems to be only an argument if there's actually a basis in the agreement for the kind of, all I need to show is reasonableness. I don't even need to satisfy my employer that that telework is consistent with the agency's ability to accomplish its work.
Well, to be fair, though, that presents the layering of the unreasonableness language makes all of those preliminary determinations by the agency also potentially subject to arbitration. So it makes the entire denial.
Aren't they subject to arbitration anyway?
Well,
I mean, they wouldn't succeed, but they're still subject.
Right. But so the question that the authority answered was, does this have an effect on a management right? Is there some effect here on management's right to assign work and direct employees from this article? And the union is arguing no, because they are entirely free under the article to deny telework for reasons not listed for any reason. And the fact that there are a lot of reasons in the articles that the agency could cite to deny telework doesn't mean that it doesn't have an effect on management's rights. It just means that, well, there's a slight effect, perhaps. Maybe it's not that bad of an effect, or maybe maybe it's an effect, but it's a tolerable one, and really the agency should just live with it.
Yeah.
Because but the issue here is just whether it has an effect. And so if there's an exception under management rights for procedures by which management's rights will be exercised. So if the union is free to argue, look, all we're doing here is just channeling management's discretion into a series of procedures, right? They have to say that the job is suitable for telework. They have to say that the employee has shown a fitness for telework, right? And there's all sorts of little procedural boxes, but this is just at the end of the day, it's a procedure for exercising management rights. That's an argument that remains open to the union. The union didn't raise that. And in fact, in the 1979 decision, in the oldest telework case that we have on the books, that's exactly what the authority held. A proposal with all sorts of little, qualifications and guidance of discretion, that was held to be a procedure. But here, the issue.
Yeah, no, I get that from the briefing. I just, because we're running out of time, wanted to ask you about the nature of the justification that the authority gave. Do you think the position, the authorities and or the agency's position rested on recognizing a management right to determine the place where work is to be performed?
So I think that it recognized that requiring employees to be out of the office, or a proposal that would effectively create a class of employees who have to be allowed to telework 80% of the time, has effects on the agency's means of supervising those employees, and it also has an effect on their ability to assign work schedules to those employees, which the authority has long held to be an aspect of the.
It doesn't affect work schedules. I mean, it was interesting that the authority kind of elides them by saying that the right to assign includes the right to determine when an employee is required to report to the duty station to fulfill his or her duties. But it doesn't really make sense, given that if you're teleworking, your duty station is your alternative work site. And nothing about this proposal, nothing about it affects the timing of when you can be required to report to your duty station, does it?
So it certainly affects whether you can be required to report to the office.
Right. That's a different question, though.
Right.
That's a where question, not a when question.
But so even in the Big Spring case, which the authority cites, that was even where the employee works within a duty.
I know, but that was a prison. That was a prison.
Right.
That was where it matters where you are. Whereas here, under the threshold determinations, the management has signed off on the notion that it doesn't matter, that the employee can do their work somewhere else. And the agency never established or even argued that the timing of the work itself changes with the location. Never made that argument.
So with the analogy to when work is performed, which is clearly a well-established.
Absolutely.
There's to prove that a proposal affects management's rights in that context, there's no tie to the nature of the work, saying, well,
right,
that only applies if there's some tie between the time of day when the work is performed and the work itself. So for example, in the case where employees were the proposal to allow employees to home that would be performed over the weekend, the agency didn't have to argue, well, and their work just has to be performed during a weekday. There's no way around it, No,
that's not even in dispute. So, but right. I guess my initial question, and maybe you could just tell me whether you think this is yes or no, is does the authority's ruling rest on recognizing a management right to determine the place where work is to be performed?
Yes, I mean, it's recognizing that whether work is performed in an office versus at home has effects on the supervision methods that the employer can use. For example, having to monitor employees' work virtually, not being able to have drop-ins, not being able to have unscheduled interactions. So, for example, the case where the proposal that employees work behind a locked door.
Right. Can you point us to anywhere specifically in the agency's briefing before the authority that it made any argument about or even mentioned methods of supervision?
I think it said more broadly, it said that this affects their right to direct employees, and it supported that with lengthy argument that treated the right to assign work and direct employees together. But I think the import of the argument, we have the right to tell employees to come into the office, is that this has an effect on supervision methods. And
But
also,
that was really provided by the authority. I mean, the agency never even separately cited the subsection providing for a right to direct employees. In its briefing, it never even cited that.
right. And
So,
I mean,
you're right that they assimilated the right to assign and direct, kind of like, which work are you doing and which work is another employee doing. But the supervision argument comes up with agency. I mean, sitting here today, I have no idea whether the agency cares or finds this to be an impediment. Maybe when people are in the office, it does most of the supervision by email or Skype. I know we do that sometimes in my chamber. So it just seems like this is a classic case of that not having been raised before, in the administrative process.
So the cases, for example, that about working behind a locked door and all of that discusses the right to assign work and direct employees together. So that was both an assign work and direct employees case. So the management rights are very commonly discussed together, these two, including authorities. But the other thing I would note about this is that the agency had the burden to raise arguments that it wanted the authority to consider. So the authority has a questionnaire that that they put down as far as which management rights. On J64 is FMS asserting a management right set out in USC 7106A. Yes, it is asserting its right to determine the mission and organization of the agency and its right to assign work and direct employees. And it's not required to create a factual record. And this goes back to the 1980s. Parties are not required in a negotiability petition to create kind of detailed factual records about, well, this would affect employees in this bargaining unit, this bargaining unit, this bargaining unit.
But Mr. Peters, we're really far from that, because here, and I mean, I had drawn the opposite conclusion from the citation there, 7106A. The agency refers only to mission and organization and right to assign, and doesn't even mention right to direct. So and this really feeds into what, the primary kind of failure to explain aspect. The agency never established or even argued that the timing of the work itself changes with the location, nor did the agency ever argue that its ability to supervise these kind of employees in this kind of job was impeded by telework. And then the authority doesn't distinguish the most closely analogous precedents. It just says we'll no longer follow cases holding otherwise. What about its distinction of the HHS case and the FDA case explains the reasoning for that? Or what do you understand to be its reasoning for no longer following those cases?
So, I mean, first off, the idea that, and this goes back to the DC Circuit's own cases, the DC Circuit has not required agencies to introduce evidence in support of its claim that the employee's proposal infringes the implicated management right. And that's from 1982 case 691 F second 553 footnote 49. But the other fact is, so as far as the NAGE 2011 case, I agree that wasn't with Judge Rao, that wasn't presented to the authority. I mean, there was never an argument from the union that NAGE, the 2011 case, should control. And I think that the proposal there, which just said it was just said just eligible, is sufficiently distinguishable on its face that there was no requirement for the authority to discuss it, because it's just all it said is employees will be eligible. It had no restrictions on management's.
So Mr. Peters, do you believe that we are jurisdictionally precluded from considering that issue?
Yes, I would agree with that. I think that the issue of whether NAGE is on all fours is not raised by the union before the authority at all. It was just cited as one of many cases, but it wasn't. There was not this fulsome argument that NAGE is on all fours was certainly not presented to the authority.
Let me ask you another question. I mean, if we did have jurisdiction, I mean, one of the authority's arguments to what the union has argued is that the agency didn't in fact forfeit these arguments about the right to, you know, the various specific management rights, that they weren't forfeited before the FLRA. And so I guess my question is what is the FLRA's ability to, like, say we assumed that the agency did forfeit its argument, what authority does the FLRA have to excuse such forfeiture? Because the regulation allows the FLRA to excuse forfeitures when appropriate. And so what standards does the FLRA use for that?
So I think that I know that there is authority case law. There have been authority cases, for example, where even when parties seek to dismiss negotiability appeals, the authority will say, no, we feel like the labor management community is benefited by our decision. So it will not even respect the party's desire not to have a case decided in some cases. There is precedent that we can get you on that, where the authority said, no, we want to decide this. And so there isn't a lot of, so basically the cases cited by the union in support of its forfeiture argument are cases where a party made a bare assertion or presented no explanation of how the proposal would affect management right. I mean, at the very least, the agency here presented an elaborate explanation of how the proposal would affect the management right. It wasn't, in some ways, it wasn't the precise reasoning used by the authority, certainly, but there isn't a whole lot of case law here on the gray area, perhaps gray areas where a party says, no, like in this case, we believe that it infringes on the right to direct employees and says that the management rights are overlapping, as it did in its brief. But then, it doesn't make quite the same argument that the authority ended up making. So the cases that the union cites are really just, they said nothing or buried.
And it does seem, it does seem to me that this regulation, it's not even clear that the regulation imposes a mandatory requirement on the agency to not consider arguments that are forfeited.
That's absolutely, yes, that is absolutely right. That is completely true. All it says is a party must raise and support its argument. So I think what it does is it creates a ground floor of you don't have a right to have the authority decide this issue if you don't raise it. But it doesn't limit the authority's discretion to consider things. And in fact, agencies, as you well know, routinely do that. Very frequently will consider issues that are not raised by parties. And it creates interesting issues for this court when the authority has certainly raised issues sua sponte in many cases. So that is absolutely right. It doesn't limit what the authority can say. It limits what parties have entitlements have.
And I think that's in sharp contrast to the statutory exhaustion requirement on us, on this court, which is jurisdictional.
Yes, that is absolutely right. The 7123 bar is jurisdictional. This is really just to give parties notice of what they have to say in their briefs in order to get the authority to decide an issue that they wanted to decide. But of course, there's legions of cases where the authority has raised issues sua sponte, and it creates very difficult 7123 issues sometimes when that happens, but not here in this case.
All right, Mr. Shaw, why don't you take 2 minutes and let me say before you respond that when I caucus with my colleagues, because this jurisdictional issue is frankly a new one to me, I'm going to ask both of you and hope my colleagues agree with this, to submit something on jurisdiction and on forfeiture. So in other words, I'm saying you don't have to answer everything in the next 2 minutes and refute the jurisdiction issue.
Thank you, Your Honor. A few points. To begin, I just want to make sure that we're clear on the operation of the proposal, because that was discussed at length, and management's hands are not tied in the way that our friend on the other side indicated. Just at the ground level, to apply for expanded telework, certain things have already occurred. The agency has already determined that because of your position and your duties, your physical presence isn't required in the office for the days you're teleworking. You have a fully successful performance rating. The agency
Could they change their mind on that? They'd let you do a year at the limited telework. You want extended telework. Either the agency's assessment of how it's gone or that something about the nature of the work has changed. And they say your physical presence is now required. Is that subject to a reasonableness overlay or not?
Yes, the agency can change its mind. If at any point it believes that the telework arrangement is interfering with the accomplishment of the agency's work, that is explicit in section 20.06 of the existing telework article, it can rescind the telework arrangement. And even beyond that, if there is a specific—
And it's not, and in terms of whether it's subject to this reasonableness overlay, is everything in what I'm referring to as the threshold conditions for telework subject to reasonableness overlay or no?
There is not explicit reasonableness language in the existing telework article. It simply gives the agency that authority to make that call. And it says decisions will be made on a case-by-case basis in terms of the interference with the agency's ability to accomplish work. So at any point—
That was a little bit hedged. You said it's not explicit. Is it the union's position that it's implicit? I mean, this is actually really important in terms of Mr. Peters's objection.
Your Honor, so two things. One, the text is not cabined. Whether an agency would disagree with an agency's view on this particular point, I don't know.
So, for example, under 20.06, other considerations, the approval or disapproval of an employee's request for telework will be based on whether the approval will interfere with the employer's ability to accomplish its work. The employer gets to make that decision.
Yes, that is correct, Your Honor.
Unilaterally.
The employer makes the call unilaterally. But that's not to say, Your Honor, that if on its face that conclusion is baseless, for example, that there may not be disagreement on that point. But
now, is that something that the grievability of which has changed or would change under the proposal?
No, Your Honor. The proposal inserts limited language into the existing telework article. So the provision we were just speaking about regarding the interference with the agency's ability to accomplish work, that is language that is already in the existing telework article that would be retained. The proposal would simply supplement the existing telework article.
Right, but you're saying that if they made up a reason that it didn't interfere with the employer's ability to accomplish its work, before this proposal, you're saying if they just made up a reason, that would be subject to grievance?
Your Honor, my understanding—
And it doesn't change because of this, what I'm calling the reasonableness overlay.
Yes, Your Honor, but my understanding is the status quo would remain in terms of anything in the existing section 20.06, anything that was grievable would remain grievable.
And it wouldn't become more grievable on a new ground because of the not unreasonably denied provision that applies to extended telework.
Yes, exactly, Your Honor. The status quo would hold as to 20.06. The new language regarding expanded telework, it's a supplement. And the provision in question here regarding employee requests for expanded telework not being unreasonably denied, that is, again, a second layer of management discretion, even after you've jumped through all the hoops. And you're one of the employees who the agency says is in an ideal circumstance for telework for 6 days per pay period. You've already met that threshold. Then you apply for the expanded telework. Agency management, again, can deny that request, consistent with the proposal. So there is no situation here where the agency management is being dictated to about who can come to work or having, the union dictate how employees are going to be supervised. There are several layers of agency discretion here. And again, both of the bargaining parties viewed it that way. The record is clear that both of the bargaining parties agreed that management would retain its existing discretion under the party's existing telework article when it comes to denying telework requests. That's essential. And that can't be reconciled with this presumptive entitlement to 80% telework that the majority believes exists based on the plain wording of the proposal. There is no support for that, and that's squarely in conflict with the record. Second, Your Honor, much of what you heard today from the authority related to telework grievances, complaints about grievances, and that's true also in the agency's briefing below. Those are policy arguments that have no bearing on the legality of our proposal. This is a matter that should be settled at the bargaining table. If the agency doesn't like our language, it can counter it. If the agency doesn't like telework grievances, well, the scope of the negotiated grievance procedure is itself negotiable. They can do things to take care of their policy concerns, and they should do it at the bargaining table. Those things bear no relation to the legality of our proposal. Next, I just want to make sure we're clear on the right to direct argument in terms of the regulations and what I think is undisputed, that the agency below made no mention of employee supervision whatsoever. I want to make clear that our argument is based both on the regulations and the authorities interpreting precedent. That precedent uniformly holds that where agencies do not support their management rights arguments, where they're just bare assertions, the authority will not rule upon those arguments. We cited a case in our reply brief issued during briefing in this very case, where there was a telework dispute. The agency raised the same two management rights arguments that are at issue here, the right to assign work and the right to direct employees. And the authority held it wasn't going to consider those arguments because they were bare assertions.
But Mr. Shaw, those precedents don't tell us whether the authority has the ability or the authority to consider forfeited arguments. They just tell us that in those cases, they decline to reach a forfeited argument. It doesn't tell us whether they must not reach a forfeited argument.
So two things, Your Honor. One, the regulatory construct anticipates parties raising and fully supporting their arguments and the authority adjudicating those arguments. And as Your Honor pointed out, the authority hasn't explained and didn't explain in its decision when it will nonetheless reach management's rights arguments that were not made below. Even if Your Honor is correct that the authority has that discretion to reach arguments that were not made, there is nothing in the decision below to explain when that is appropriate. And so this court is unable to address whether the majority's rationale in reaching the argument below was arbitrary or rational. It needed to explain why it chose to really create and then adopt that supervision argument. And again, the regulations aside, there was no explanation for the authority's departure from its precedent, which, and there's no dispute about this, consistently holds that management rights arguments will not be reached where they're just bare assertions.
All right. please wind it up. You have one more point? All right.
Yes, the last point I want to make is just on the NAGE decision and whether it was raised below. At GA 179, you'll see that the NAGE decision, among many others, was raised by NTU below. And that decision, we believe, is on all fours with this case and should have governed below. Thank you.
All right. We have your arguments, Madam Clerk.
This honorable court is now adjourned until Friday, February 12th at 9:30 a.m.